Hi everybody, welcome to my channel, Life, Law, Bin. Hi everybody, welcome back to the channel, and today I am very excited because I have Mr. Andrew Powell from Four Paper Buildings. Um, he is a barrister, so we have him today and he'll be talking to us about a career at the family bar. Now I know that this will probably be very intriguing and exciting for those who are interested in pursuing a career at the bar and family, but I do promise it will also be exciting for those people who maybe are not interested in family specifically, because we'll be talking about surrogacy, and that's definitely something that we know about from our television shows or maybe from celebrities. Now, one interesting thing about Andrew is that he has written a book on surrogacy, and that's entitled A Practical Guide to the Law in Relation to Surrogacy. And he published this book in November 2020. So, congrats on that, Andrew.
Thank you so much, Nia, for that very generous introduction. Yes, I wrote that book during when everybody was on lockdown, really. I was still working, but it was a bit easier to kind of put my mind to doing it, but I wasn't going away on holiday. So it was kind of that was my holiday, writing a book.
Very enjoyable holiday that is. So we'll get started by asking you. We're gonna track your journey throughout the law, and we're gonna start with your first degree. So could you give us a brief overview of your first degree experience?
Yeah, so my undergraduate degree was in social anthropology, which I studied at the University of Manchester in 2002 to 2005, to give you a kind of a ballpark of how old I am. And it actually came about as a quite an odd feature, really, which perhaps is something which students listening would like to know about. I hadn't planned to study anthropology at university. I had a place to read law, and the night before I got my A level results, I thought this isn't going to happen. I had a feeling I'd missed out on one of my exams, and wasn't going to make the cut. So I remember buying the Independent on the day I got my exam results to see the clearing list, to see what other courses I could do. And the newsagent was like, "You won't need this. You're like an A grade student. You'll be fine." And of course, I got my over results, and I didn't get the grades I needed in one particular subject, so I didn't get my place. And I didn't want to go to my insurance university, so I thought, you know what, I'm going to go through clearing. So I thought anthropology sounded interesting, and the first year was quite difficult actually, because I think I was still in this kind of weird world of wanting to do law, and it was a bit strange to me to think, how am I going to get to become a lawyer still? And by the end of, well, by the beginning of the first term in second year, I'd come to really enjoy it. And I think because anthropology is fundamentally, particularly social anthropology, is about people and how people view the world from their kind of cultural perspective, it actually translates quite well to law, and particularly to family law, and in one sense, because as an anthropologist, you're often the voice of the unspoken voice. So the anthropologist is sometimes an advocate, although they don't try and use their kind of cultural or ethnocentric kind of views to kind of interpret something, but they're still kind of saying this is what happens, and trying to explain it through another person's lens, which essentially is what an advocate does sometimes. So I spent 3 years at Manchester doing that, and I thoroughly enjoyed it. And one of the areas which we focused on was in relation to kinship and family formation within Western or Euro American culture. So you can kind of see how that kind of translates into a nice segue into family law. Although I think during my second or third year at university, I was still quite keen to become a barrister. So I was doing many pupilages in London and in Birmingham. And I decided to apply once I finished at Manchester to do a law conversion. but rather than do a 1-year GDL, I did a 2-year LLM at Leeds University, where it was a bit of a different format to the GDL in the sense that you were doing all of the qualifying law degree components to the course, but you were taught with LLB undergraduates, and then you had to do kind of additional work or additional coursework. So it was spread over 2 years, and it kind of, I mean, in theory, I suppose it's meant to mean that you're meant to know a bit more, but I mean, I probably could have just done the GDL because I still don't know anything about land law and tenant equity and trusts, even though I did it for a longer period than I would have done on the GDL. But yes, I did. Yes, I did 2 years at Leeds after Manchester, and then from there I did the BPTC. In fact, it was called the BVC for me. It was that long ago. The BBC in 2008, and I suppose I should add, before I was very fortunate actually that I applied for pupillage in my final year at Leeds when I was doing the LLM, and I got offered pupillage. So I started the BBC with a pupillage, which was and still is very rare. And I was incredibly lucky and privileged to start bar school knowing that I had a pupillage at the end of it, providing I passed the bar exams, which I did.
Yeah,
Just
what you did. No, what you did. So that definitely was a whirlwind, a quick overview of your legal experience of joining the law. But I think one key thing we need to highlight there is that bad or grade that you don't want, what we call bad grades, isn't the be all and end all. Often it may be just a slight setback, but if it's something, and I know Ayana was telling me this in a previous video, if it's something that you definitely want, it may just take a little longer, but once you continue to be determined and go after it, you end up on that path anyway, and here you are.
well, I couldn't agree more. I mean, there's often more than one route to get to a destination. You can get the central line straight there, you're there directly, or you may end up taking the circle line and it taking slightly longer, but you get to your destination, you still get there.
Yeah.
And it can be difficult because I think at the time, particularly for somebody who is used to, who is performs well in exams, to get these knockbacks unexpectedly can be quite a shock at the time. And I think it can be difficult to acknowledge that also at the time, but you can turn those experiences into positives, because it's, my goodness, a career at the bar, you're going to have setbacks.
Yeah.
And I suppose particularly for if you specialize in family law, I really don't really think anybody really wins in family law, because if you're in a courtroom, it's pretty grim probably. But there are cases where you're trying to advocate for a particular outcome and you might not get it, and so you're not going to win all of your cases, so you have to kind of be prepared for that, because I think it ultimately makes you, it's part of it's character building. It sounds really cliche, but I think it's a relevant part of your journey as a practitioner.
Yeah, and I mean, character building could be really grueling. Songs so fancy and nice, but getting those setbacks, it really does hurt for a bit. But I think the important thing is to process it and find a coping mechanism and
Mm.
move forward. Just keep moving forward. Now, I know you said that you studied, well, you obtained pupillage when you were doing your LLM. So, what did you do your LLM in, and what was that experience like for you?
So on the Leeds course, so you did all the kind of like the core components of the qualifying law degree, and you did additional modules. The additional module I did was, funnily enough, family law and society, which kind of dovetail really well with my experience as an anthropology undergraduate. And then there was also a kind of a big component where you had to do a kind of a kind of an extended dissertation that I think was almost 20,000 words. I think was the limit. I did that on judicial review, and interestingly, actually, I did it on judicial review, and I looked at specifically at, as it was then called, I don't know if it's still called it now, but I looked at the National Blood Services policy on their blanket ban on gay men donating blood. And it's interesting because it's in the last, I think, 6 months or so, the government have announced that they're going to allow gay men to donate blood if you meet certain criteria. And so that was a large component of my LLM, was looking at judicial review and the lawfulness of that particular policy. And it's, as I say, it's quite interesting that, 13 years later, having done it in 2006-7, the government finally kind of changed it. I mean, they've not changed it completely, but they've done basically what I was saying in my dissertation, that you needed to have a holistic kind of evaluation of a person's sexual history, rather than it being focused on their sexuality. So I really enjoyed doing the LLM, actually. I think because it was more, it didn't feel as rushed, and I think I quite liked being a student. Wasn't quite ready to kind of pop out of that student bubble, or leave the north of England, frankly, at that point.
I quite like the north as well. I did, yeah, I did all my studies in the north here in the UK, beginning with Newcastle, and I'm now in Leeds. So it doesn't seem like I'm venturing too far.
Yeah, no, I think it's really important, actually, because I think people often think I, well, at least I hope they don't think that, but I always try and make clear that I'm not this kind of London-centric uh, person. I was born in Birmingham. I grew up in Birmingham until I was 18. Went to university in Manchester. Lived in Leeds. Then moved to London. And so I know there's a world beyond the M25 that has different experiences. And yeah, as I say, I quite like leaving London. you know, um, and I think I value, actually, particularly when you go to court in a different city. When we used to go to court regularly, it's quite nice to see like another place. So I quite enjoy getting out of that London bubble.
Yeah, definitely. And I know you're also a scholar in terms of you attained a Pegasus scholarship in 2013, and then
Yeah,
a Bedingfield scholarship as well from Gray's Inn in
yeah.
2017. I'd really like you to share with our viewers a bit about attaining those scholarships, and how that basically propelled your career, or assisted in any way.
Yeah, so the Bedingfield Scholarship I was awarded in 2007, and that I applied for that when I was in my final year at Leeds, and that was to basically for the bar year that was about to start. And foolishly, I had no idea about scholarships until very late, because had I known about them, I think I would have applied for it for part funding the GDL. And I applied for it in 2007, and I remember being interviewed by, well, Quinn Clark was on the interview panel, who was until recently the director of education at Gray's Inn, and a number of silts, and I think maybe a high court judge. And it was, it was a good practice run for pupillage interviews. So I think I was doing an interview for Gray's Inn for the Bedingfield Scholarship, and then weeks later, pupillage interviews. It was a good kind of practice run. And I was lucky. I did well, and I got a Bedingfield Scholarship, which I think was one of the top three scholarships at the time. They didn't have the Baroness Hale Scholarship then. I think there were maybe a couple more that were awarded more than the Bedingfield, but it helped substantially because it paid for all of my bar school fees, which were, oh gosh, I can't remember what they were, but they were well over £10,000 for the year, which is a huge amount of money. And I had money left over for accommodation, which at the time in 2008, 2007, 2008 went a bit further than it probably would do now. So that was a real launch pad that was really invaluable. And there's a there's kind of coming full circle in one sense, because in the last few years I've now been on Gray's Inn scholarship panel so I've now been on the panels interviewing people for scholarships. And so it's kind of a bit funny that 13, 14 years later you're now interviewing the law students, which is a bit odd, but it's quite enjoyable to be able to kind of give back what I received. And then the Pegasus scholarship is part of Inner Temple, so it doesn't matter which inn you're a member of, but they run this scholarship where you can go to another jurisdiction to, maybe not really to work, but to perhaps shadow lawyers in that particular jurisdiction. And they've got a few pre-arranged programs So going to DC, going to New Zealand, going to Australia, or you can approach the inn and say, this is what I plan to do. And I was really interested in surrogacy law. So when I applied, I said, look, I've been in contact with a law firm in the US, based in California. I need X amount of money to sustain me for 3 months. That's where I'd like to go. So I had another interview for that. And it's a fairly rigorous kind of process. And I was successful in getting that as well. So I got it in 2013, but I was in the middle of a really long trial, like a 6-week trial. So I ended up having to postpone it, and I didn't go until the beginning of 2014. And it's a scholarship that's only, I think the eligibility is 6 years cool or so. And I think I was just on the cusp of it because I had applied pretty late. But it's great because it meant I went and spent 3 months in Los Angeles at a law firm that specialised in fertility and surrogacy law, where the law is completely different to what it is here. And it was actually fascinating. So living in another city, not Leeds, not Manchester, not Birmingham, but LA, was great. And of course, by that point, I was 5 or 6 years cool, so it was kind of a ideal time to kind of have a step back and see another jurisdiction, see how it works there. And it's created. I mean, the part of the ethos of Pegasus is to connect lawyers from around the world and to create a family of international lawyers. And I've really benefited from it because I have kept in contact with the people I worked with. And it's meant that I'm now a member, or I have been for some time, a member of the American Bar Association family law section as an associate member from another country. And I've been to maybe 3 or 4 conferences in the US since I did my Pegasus scholarship, and 2 of which I spoke at as an English lawyer. So it strengthened that relationship. And I often get referrals via firms I worked at who go, and the client goes to another solicitor and they say, oh, Andrew does this kind of work, you might want to instruct him. So it's been extremely beneficial, and in fact I'd probably say career changing, really, because it was a real kind of change in the chapter of where my career was going.
Interesting. And I feel like this is the opportune moment to really delve into surrogacy now. And I'm just thinking to myself that that experience in LA must have, got you thinking or reflecting about the legal framework here in England and Wales, in comparison to what is operating in specifically LA or in different states within America, and maybe thinking about where the law is. In England and Wales, and where it needs to go. So, what kind of perspectives did you start to formulate or conceptualize, as you returned to delve into this area?
Well, it's such a good question. At the time, when I was out there, I created a blog to kind of chronicleize my time in LA, and the blog was called Wig and Gown in Tinseltown, which sadly is no longer available online. So I don't think I paid the blog website the amount to keep it going. But I think when I was out there, because the system in California, and it's important to emphasize, as you said, the states, because it's not all 50 states have the same law on surrogacy. It's all state driven, it's not federal. So states like California, Nevada, Wisconsin, Illinois have very similar statutes where surrogacy is effectively a profit-making industry, but it's regulated. And so the thing that struck me about it was that each of the protagonists within a surrogacy arrangement knows where they stand. And so the surrogate is represented by their own lawyer. So too are the intended parents or the intended parent. And it's much more transactional rather than it being adversarial. So I observed, for example, the intended parent's attorney telephoning the other lawyer representing the surrogate, say, I'm just looking at the contract. It doesn't say this. Perhaps we should put this in. And then saying, actually, that's a really good point. Let's put that in. So they were all working towards the same goal. And because everybody's represented, they're protected in a sense, because there is an equality of arms rather than there being this, rather than there being, I suppose, a potential for there being a disequilibrium between unrepresented and represented parties. A significant feature, for example, in California, is that intended parents can obtain parental rights prior to the child being born. So they can obtain it in utero, normally midway through the third trimester. They can get what's called a pre-birth order. And the pre-birth order says that X and Y will be the parents of this unborn child, and once born, they will be the parents. And so they're then issued with a Californian birth certificate, for example, that says they're the parents. And there was some research done recently that highlighted that one of the reasons why English intended parents, or UK intended parents, often go to places like the US or particular states in the US to do surrogacy, is because there's a greater certainty in terms of the acquisition of parental rights. And here it's very different. And so I suppose there's two ways to look at it, because even if you have a English couple who go to the US, enter into a surrogacy arrangement, and they come back to the UK where they live, where they're domiciled, they're still not necessarily recognised automatically as the parents, and they have to go through another process and apply for what's called a parental order, which is the bespoke order for children born via surrogacy. And it's a bit like an adoption order in the sense that it extinguishes the surrogate's parental status and her husband if she's married, because of course if she's married, he's also seen as the parent regardless of genetics. And often it's probably important to note that in the majority of surrogacy arrangements, the surrogate is what's called a gestational carrier. So it's often a donor egg, it's not her egg. But the law in this country says that the woman who gives birth to the child is always the mother, regardless of genetics. So even though the woman who gave birth to the child is not genetically related, even though a competent court in California has ruled that the intended parents are the parents, when they come back to the UK, they're still not recognised as the legal parent, and they're not obliged. There's no law telling them they have to do it. But if they want to have proper recognition with the child, and of course it's important for the child too, for them to be recognised as parents, then they have to apply for what's called a parental order. And I suppose the other side to consider is that when it happens here, it's exactly the same position. So surrogacy in this country is permissible, but it has to be altruistic. So you can't have a commercial arrangement, but it's the same principle. So if you have a couple who have a friend or a relative who wants to be a surrogate, which is perfectly legitimate and happens regularly, they still have to apply for this parental order to be recognised as parents. And so I guess what I saw in terms of what I saw in the US versus here is that the legal certainty isn't as assured as it is in say like California, which I suppose brings us quite neatly on to some of the areas where it might be reformed, because the Law Commission, as I'm sure many of your viewers may or may not know, actually, I suppose, have been looking at surrogacy and areas of possible reform. And they started that 13th consultation, I think in 2018, 2019. And one of the proposals is to create a new pathway that would, if certain criteria are met, the intended parents would be recognised as parents at birth. So it would avoid this kind of limbo period where the intended parents aren't the parents. And the problem is that, and I should emphasise, it doesn't happen often. I mean, certainly in my experience, I think because when we talk about surrogacy, people often think of there being a dispute, because they think of it within the context of celebrities or what's happened on soap operas. But generally, you don't often get disputes. I mean, or if they are disputes, they're not litigated. I mean, I'm not seeing them. But I accept I'm involved in some cases where there are disputes, but they're not they're not everyday cases. They're quite rare. Although I should say, when they do have disputes, they get quite difficult. But the point is that the way in which the law operates is trying to provide certainty, and these proposals are trying to achieve that by saying you're the parents at birth. But as I say, the problem that can occur is that because they might not have any legal status to the child, if, for example, that child post-birth requires emergency medical treatment, maybe the baby was premature, they're on a NICU, a neonatal intensive care unit, the person who has to consent for treatment is a surrogate, not the intended parents, because they haven't got any legal status to give them that authority to do so. So that's where it kind of gets complicated, and why, if I haven't already said, why some people go abroad, because they think there's more legal certainty, but they don't recognise sometimes that even though they've gone abroad, when they come back here, they still need to get an order that recognises them as the parent.
Well, it definitely seems like a very intricate and complex area of law. And I think on the face of it, it's almost like we would think, the average person would just think it's open and shut. And as you said, I guess from what we see on television, more so transactional. You'd think it's
Mm.
transactional right across jurisdictions. So I'm really happy that you highlighted that key difference. But what's clear is that it seems like, like many other areas of law, there are a lot more advancements needed and a lot more thought to go into the balance of rights and as you said, striking that equilibrium in terms of
Mm.
power, because imagine how should I put it, the intended parents or the genetically related parents to the child, they may feel stressed that they can't even give consent for a child to obtain some kind of emergency medical procedure. So it's almost like you're in a period of limbo and
Exactly.
uncertainty, and
Exactly.
you're just waiting on the courts to give you permission, which seems, because in this area of law, I am the average person. I don't know much about it at all, which seems almost incredulous, because if I gave the egg and it's genetically related to me, I'm thinking to myself, okay, well, it's mine biologically, so I should be able to do this. So it really does show to all of our viewers that there's still a lot more progress needed, specifically in that area.
Yeah, I mean, it's fascinating actually, because one of the other things which, again, a kind of a comparator to adoption is that the government has a recognised list of countries that's approved by the Home Secretary. Um, if you have an adoption order from X country and you are habitually resident in this country at the time of the adoption was made in that country, it's automatically recognised here. And so some people think there should be some form of recognition that if you've gone to a competent jurisdiction that's approved, and the approval process tends to mean where the UK government is satisfied that in that jurisdiction the laws pertaining to surrogacy are similar to ours, or the key being it's not exploitative, then it should be recognised automatically, because it's actually quite a big deal to have to, if you particularly think of it in context. I think it's probably a lot easier for same-sex male couples because they can't have children naturally. But if you're an opposite sex couple who has gone through fertility problems, often very traumatic process of miscarriages, you may have tried adoption and felt that wasn't for you, and you think, do you know what, let's do surrogacy. And they've sometimes they have to remortgage their houses. They borrow money. They go to somewhere like the US. They get it all done, and they think, "Gosh, I have to come back to the UK and apply for another order to be recognised as a parent and have this level of interference with their private and family life." That isn't, compared to the average family case, it's not the same level of interference, but it's an interference nevertheless. And that's something which can be kind of off-putting. But it's an area where it can be seen as a kind of a political hot potato, because it's kind of, it involves kind of ethics, morality, and you often don't get kind of a same picture on it. But actually, it can affect anybody, because we know that things like fertility issues are commonplace, and it's something which is there. And the Law Commission, in their kind of the exposition to their consultation, have said that surrogacy is a legitimate way of forming a family, and that, as you said, the law needs to catch up with it. And I think that's sometimes a problem, that the law hasn't kept up with changes in society. And the reality is that, and I guess this is the beauty of family law, that often it's it's within the context of the family courtroom where these changes emerge. Um, and so, we as the lawyers and judges are trying to uh, plug the gap whilst the law catches up. But government's very busy, doing other stuff, so it's not always a priority.